Hello, everyone, and welcome to today's webinar, Exploring the CCUS Regulatory Environment in 5 Questions. We're pleased to have you join us today. Today's session will be recorded and made available to watch afterwards on the albertacarbonhub.com and the Carbon Management Canada YouTube channel. My name is Tamara Gale, and I am the Senior Marketing and Communications Manager for Carbon Management Canada. Before we begin, I'd like to acknowledge and pay tribute to the traditional territories of the peoples of Treaty 7, which include the Blackfoot Confederacy, comprised of the Siksika, the Piikani and the Kainai First Nations, the Tsuut'ina First Nation, and the Stoney Nakoda, including the Chiniki, Bearspaw, and Goodstoney First Nations. The City of Calgary is also home to the Métis Nation of Alberta, Districts 5 and 6. Today on this land and in this place, we strive to learn and grow together in a good way. So thanks again, everyone, for joining us. We've still got some people rolling in, but we'll keep things rolling as we have some great information for you today. So we're going to kick off today's session by welcoming you and our guest speakers to the webinar. We'll do a quick introduction, followed by a presentation from the AER, and then a look at the regulatory environment from a commercial perspective with Bison Low Carbon Ventures. We'll wrap up the webinar with your questions, so please do type your questions throughout the session today into the meeting chat or the Q&A, and we'll be sure to get to them after the presentations. Before we begin our introductions, we actually have a quick poll for you to answer. So if we could ask for your indulgence to please turn your attention to the questions that will appear on your screen, that would be fantastic. It will help us develop great events for you in the future. So Kaylin will just start that for us. And then I think there's just 3 or 4 quick questions for you to go through. So if you could tell us a little bit about your familiarity with the CCUS industry, and there's a range there for you to choose from, and how interested you are in learning more about the sector and its regulatory environment. And perhaps which best describes you, if you work in the energy sector, are a student or researcher in energy-related fields, or if you live in Canada and are interested in learning more about CCUS, or perhaps you're new to the country and are interested in learning more. Once you've answered those questions, please click Submit at the bottom of the text box, and we'll record your answers. So thanks again, everyone. I'm looking forward to diving in today. I'd like to introduce you to today's speakers. Matthew Brister is a Calgary-based geologist active in energy mining and energy transition technology. He was a founder and promoter of 9 energy startups, so this may not be his first time around the regulatory arena, and his companies have operated successful exploration programs and developed production in Alberta, BC, Saskatchewan, onshore and offshore in Tunisia, and offshore the North Sea. Matt serves as a director of 20 companies and serves as board chair of 7 of those companies. Matt is currently president of Bison Low Carbon Ventures. He's an active fellow of CDL Rockies and a director of 3 not-for-profit enterprises focused on education and health. Matt's company, Bison, was awarded 2 CCS Hub tenures in 2022, was awarded the second carbon sequestration agreement for the Meadowbrook project in July 2024, and has regulatory applications in front of the Alberta Energy Regulator at present, and hopes to be in a position to be licensed for CCS Hub operations later this in 2025. So it's an exciting time for Bison, and we're excited to hear from Matt about that today. Dr. Isaac Amponsa is our other speaker, and Isaac is a senior advisor focused on the regulatory at the Alberta Energy Regulator. Isaac joined the AER in November of 2013, and he leads the development and implementation of high-priority regulatory change initiatives within the AER in support of shifting policies, legislation, and innovation. His recent work includes updates to several of AER's directives, including requirements for carbon capture, utilization, and storage, and hydrogen. Isaac has over 2 decades of experience working for the federal government of Canada, the Alberta provincial government, and the Ghana Forestry Commission in consulting roles and as a regulator. During his career, he has provided technical, policy, stakeholder engagement, and regulatory expertise to projects in oil and gas, mining, quarry, sand and gravel, and forestry sectors. Isaac holds a Bachelor of Science in Natural Resources Management from the University of Science and Technology, Ghana, a Master's of Science in Forest Science from Lakehead University, Thunder Bay, Ontario, and a PhD in Soil Science and Plant Nutrition from the University of Alberta here in Canada. So welcome to you both, Matt and Isaac. Thanks for joining me today for the discussion.
Thank you.
So at this point, I'll hand this over to Isaac and ask you to share your screen, Isaac, as Isaac's prepared a presentation to share with us today.
Can you see my presentation?
Yes, we can see it. Thanks,
Is it
Isaac.
the view is good?
Yes.
Okay. Thank you for the introduction. So I'll be speaking to the CCS or CCUS regulatory framework in Alberta. As you pointed out, it's an exciting time in Alberta's history, and based on my overview, you get a sense of what I'll be talking about. So I will talk about the history of CCS in Alberta, how CCS schemes are regulated in Alberta, what's the role of the AER and the other government agencies or departments, and how does a company receive CCS project approval? What does our application process look like? And how do we ensure that these activities are safe, protect the public and the environment? And then a key component of this is the monitoring, measurement, and verification plans that goes with each of the approvals. So CCS, I don't know how many of you, the polls that you showed, how many are familiar with that, but as you can see from the schematic, we have CO2 coming from different industrial sources that get captured. You have a pipeline that is going to transport the captured CO2, and then there will be wells that are drilled, and the CO2 injected as into deep formation. So that's the carbon capture system. We also have components called utilization, which typically, currently in Alberta, for the most part, we are dealing with the enhanced oil recovery. So CO2 is used to enhance our recovery. So that's where the CCUS come in from Alberta context. But in other sectors like the beverage industry, fertilizer, chemical manufacturing industry, and cement, some are looking at utilizing the CO2 as well. So certainly it's a lot of opportunity to utilize the CO2 in other sectors. CCS typically excludes the utilization, where you're looking at those technologies capturing CO2, transporting it, and then injecting it into a deep formation. It can be either in a saline aquifer or depleted oil and gas reservoirs. So when it comes to the history of CCS in Alberta or CCUS, what I like to say or point out is that the regulator has been in existence for over 80 years. And our oil and gas regulatory framework is a foundation for how we regulate the oil and gas industry. And the CCS regulatory enhancement is built upon the existing oil and gas framework. So back in 2010, 2011, the government of Alberta initiated an assessment of a framework to try and understand what can be done, what do we have in place that can support the deployment of CCS, and what are the gaps that we need to address to ensure that the deployment of CCS can go on smoothly, protecting the public and also ensuring that the environment is protected. The work was supported by the government. There were people from academia, industry, other government agencies, researchers, stakeholders were all involved in the process. It led to about 70 recommendations, and these recommendations identifies areas of opportunities, and I can share with you that some of those recommendations continue to guide the AER in our current regulatory development or enhancement when it comes to the carbon capture space. So how are carbon sequestration scheme regulated under provincial legislation? We do have a number of legislation that govern the operations of CCS schemes. What I would say is that again, emphasizing that the oil and gas regulatory framework provides a foundation. And as you can see from the slides, we have the Mines and Minerals Act. So the Mines and Minerals Act back in 2010 was amended by the government to ensure that pore space ownership is clarified and also highlighting the government's role in the CCS space post closure. Of the carbon sequestration tenant regulation was also created back in 2011 that set out a framework for how government was going to manage carbon sequestration tenure. We have the Oil and Gas Conservation Act, the Oil Sands Conservation Act, and the Coal Conservation Act. Approvals for captured facilities that are regulated by the AER can be licensed under these acts and associated rules. The Public Lands Act, Service Right Act, these are acts that deals with surface access. And so for companies to be able to operate in a surface facility or subsurface facility, they would have to obtain Public Lands Act approval to be able to do that. The Environmental Protection Enhancement Act is one of the keys legislation that deals with the environment, particularly when it comes to air, reclamation and remediation aspect of the facilities. Water Act is also a key requirement. Some of these capture facilities, depending on how they are built, they may have to increase their water need or use, and so they will need approval or amend their existing approval. So again, these are just some of the acts that we can share with you to highlight that we do have a robust regulatory framework built around the oil and gas regulations that helps the government to really deploy the CCS in the province. When it comes to roles and responsibilities, as I mentioned, we have Alberta Energy and Minerals. They are the policymakers when it comes to the framework that enables the advancement or the deployment of CCS in the province. They are the ones who issue tenure rights for CO2 sequestration for a company to be able to come to the AER to apply for approval to drill a well. For purposes of evaluation, they need to have the appropriate right from Alberta Energy and Minerals to be able to do that. So they are the ones who are responsible for that. For Alberta Environment and Protected Areas, they are responsible for the management of the technology innovation and emission reduction regulation system that promote the CCS by allowing companies to generate credits. For all non-energy regulated facilities in the province that are looking to capture CO2, like the petrochemical facilities that are regulated by Alberta Environment and Protected Areas, they would be responsible for issuing permit approval for those facilities to be able to capture CO2. The AER, the Alberta Energy Regulator, is responsible for regulating all energy-related facilities. So for those who will be capturing CO2, we will regulate those. AER is responsible for regulating pipelines in the province. So all CO2 that will be transported by a pipeline, permits are required and AER will have to issue that. When it comes to the injection of CO2 to the subsurface, we deal with the well licensing and the injection, and so approvals uh, have to be obtained from the AER to enable those to happen. So how do companies receive CCS or CCUS project approval? As I mentioned earlier on, the AER, we are responsible for energy-related facilities that capture CO2, transport the CO2 via pipeline, and also the subsurface injection activities. We do have several directives, which I'll speak to very soon here, that lay out requirements ranging from how to license a pipeline, transport it, how to apply for CO2 sequestration scheme, and then the storage of the CO2 or into the deep saline aquifers or depleted oil and gas reservoir. Approval is required for all activities, captured facilities, pipeline, and then the wells. Each of these applications are reviewed thoroughly by subject matter experts, and if they meet our requirements, then they can get approved. We also ensure that there is a transparent process for impacted stakeholders or other operators to express their concerns for each application. So we have what we call the public notice of application tool, which is on our website. So once an application is filed, it is available for companies, stakeholders to file an SOC if they choose to. There's also requirements for notification under Directive 56 in D65 and others for companies to notify landowners impacted activities within a certain radius. So they also have opportunity to weigh into the application if they feel that they are impacted by it. So again, we don't just approve schemes or pipeline or any application. It has to meet both the technical requirements and all the other application requirements before the AER issues a scheme approval. In some cases, sometimes we have to go to hearing, and the reason being that stakeholders and the companies can resolve their issues, and therefore it has to go to hearing for the hearing commissioners to weigh in to decide on the application based on their public interest. So when it comes to our regulatory instrument, quickly, we have Directive 65, that's the subsurface directive. That's the directive that is a cornerstone to all subsurface activities. Before somebody can inject a substance into the subsurface, they need a scheme approval. There are requirements in there that deals with geology, geological containment, induced seismicity, and so on. If you're interested, you can take a look at them. For the past 3 years, we've made about 3 enhancements based on government policy changes related to carbon sequestration. Directive 13 deals with suspension requirement, and I have this in here to let you know that for a scheme to operate, the companies are required to ensure that wells within certain radius of their operations are brought to standard, because we don't want those wells to become pathways for CO2 leakage. And so before an approval is issued for any scheme, companies are required to ensure that wells within a certain radius are abandoned so that they don't become a leakage pathway. As Directive 71 deals with emergency response, they have to have that in place before they operate. Directive 56 deals with the pipeline applications as well as well licensing. It has notification requirements. So right from the time a well is drilled, stakeholders have the opportunity to weigh in before companies can even apply for the Directive 65. So public, other companies they all have opportunity right from well licensing stage till the company is issued a sequestration scheme approval to voice their concern. So we are very transparent with that process. Directive 20 deals with well abandonment. Directive 87, well integrity. Again, these are all requirements that are put in place to ensure that the wells are designed and operate in a way that doesn't allow for gas migration and other things. So what process and timeline do we have when it comes to the sequestration scheme? So when I talk about this process for sequestration scheme, I'm not talking about the application process for capture. The application process for capturing the CO2 is a different process. So for example, if somebody has an oil sands processing, an upgrader, for instance, and or a processing plant, and you want to build a capture unit as part of the integrated facility, then they have to apply to amend the existing scheme approval or the approval that they have for that particular facility. So that's a different process. It can be done under the Oil Sands Conservation Act or under Directive 56 if it is a gas processing plant. With respect to this process here for sequestration scheme application, is dealing with the subsurface. So we're talking about 3 phases and 12 steps. So the first phase is the evaluation phase. And Tamara, as you mentioned, companies are awarded hub by the government, and Bison got 2 of them. So, back in a few years ago, the government issued 25 hub evaluation agreement to 25 proponents, and each is expected to apply for a well license from the AER, and then go in and drill a bunch of wells or 1 or 2 wells to start collecting baseline information to characterize the site for suitability for injection of CO2. Once they have collected that information, they're expected to go back to the Crown, Energy and Minerals, to apply for a carbon sequestration agreement. And as you mentioned, Bison has got theirs. So the carbon sequestration agreement then allows for companies to come to the AER to apply for Directive 65 scheme approval before they can inject CO2. So at the evaluation phase, nobody has the right to inject CO2. It is only at the sequestration phase that you can inject CO2 for purposes of sequestration. And so we don't issue the scheme approval until all the application requirements applying in Directive 65 are met. And so that's what the sequestration phase would look like. When it comes to the closure phase, this is where, let's say, a company has operated for, let's say, 15 years, and they're done with their operations and they have to close the site. So the closure phase, there's a closure period that they have to go through to demonstrate conformance to whatever models that they have, to demonstrate to the government the CO2 that is injected is actually contained and so forth before they can get off the hook. Our application process timeline is 130 days, business days. So again, it can be processed earlier depending on the quality of the application as well as outstanding issues. So company submits an application and they're able to do their legwork and deal with all concerns that are raised by stakeholders or operators in and around their operations. When they notify them, if they're able to deal with that, then we don't have to deal with the SOCs. But there are other requirements that will delay the application as well. As I mentioned, if there are some wells in and around the scheme area and they haven't brought those wells to standard, the application is not going to be approved until they do that. And so there are several factors that can impact the application process timeline, but we are confident that if the companies do their due diligence and they submit their application, we'll be in a position to approve the scheme in a timely fashion. So when you look at the framework, how do we ensure that CCS deployment is safe in the province? And so it starts with the site selection and the permitting stage, where the companies get the evaluation agreement. They have to do their due diligence, characterize the site, ensuring that geologically the CO2 can be contained. There's an adequate seal. They have to demonstrate that to Alberta Energy and Minerals, and they have to demonstrate that to the regulator as well. So we go through that rigorous process, evaluate the applications before they get their permit. And then during the injection phase, um, we have other directives, and the onus is on the company as well to try and make sure that they are monitoring their operations. So when it comes to the MMV, that's where that comes in. It's central to everything. They have to install their monitoring devices to ensure that they have their eye on their operations to demonstrate that the CO2 is behaving the way they have predicted it. And then we have the closure phase where they have to demonstrate by by showing the regulator and the public that over the years of the operation, the MMV, the annual report is demonstrating that the CO2 is contained. I have to mention that the MMV has to be renewed or updated every 3 years, and there's an annual report that is submitted annually. We do have currently on our website Shell Quest and Enhance Energy's MMV and annual report. So if anyone is interested, you can Google that on our website. But it's transparent and the public can see it for themselves. So I thought I shed more light on the MMV here. So schematically, it starts from the atmosphere all the way to the injection interval. And the key here is that the activity is monitored. It's not an activity that is just going to be left to the discretion of the industry to run with it. The MMV is a requirement under the Mines and Minerals Act. So it was put in place to ensure that there is some confidence is still in the process. The public knows what to expect, and there's reporting on the MMV. So monitoring and measurement, what are they? They are surveillance activities to ensure the safe, reliable, and conformal operation of the CO2 sequestration project. So when we talk about surveillance, I'm sure everyone understands what it is. So they have to continually monitor, check, and we also have our own inspectors who will be doing some verification as well. And then the verification activities are things that the companies will have to undertake during the life cycle of the activity to make sure that whatever models they had in to begin with, they continue to refine the models, look at the model against the actual measurement that they are recording on site, and if there is any adjustment that they need to make to the operations, they will be in the best position to do that. So some of the key considerations, and I'm sure Matt will highlight that, is that baseline information is very critical to the sequestration operations. So that's where the evaluation agreements come in. It helps the companies to collect data upfront to ensure that they know what they're dealing with, so that when there are changes to the injection intervals and where they're sequestering the CO2, they will be in a better position to be able to notice that right away. The requirements that we have, we're looking at it from the outcome base and making sure that companies use the appropriate technology or new technology to do their monitoring and mitigate those risks associated with their operations. I would highlight that each operations will have a risk management plan. So this risk management plan is intended for companies to conduct a comprehensive risk assessment to identify hazards associated with their schemes and propose or have mitigation measures in place to address those hazards. Those come in as part of the MMV, which is also part of the application package. So as the AER reviews the application, we'll be looking at what risks have been identified, what are the mitigation measures that have been proposed, are they adequate? And if we are not satisfied with what has been proposed, then we have to go back and forth to the companies until they make changes to their plans or their risk profile before they can get the scheme approval. I would also highlight that there are concerns about induced seismicity associated with CO2 sequestration schemes. And I'm happy to let you know that in November here, we did release a comprehensive set of requirements that deals with induced seismicity. So as part of the application process for any CO2 sequestration, companies are required to conduct a hazard assessment and a risk assessment and create a induced seismicity plan so that they have it in place to deploy it should they detect any seismic event in the area where they are operating. So again, we are not regulating the industry to death, but we have regulations in place to ensure that there is confidence from the public side that the regulator is doing the right thing, and industry is also working in concert with the existing regulation within the framework to carry out the activities such that it is safe, it protects the environment, supports government policies, and the people of Alberta. And lastly, you asked me about career opportunities. So within the AER, we do have an array of positions. This by no means listing everything, but we have environmental science positions. We do have geologists, hydrogeologists, geomechanics, geophysics, and in the various type of engineering, legal, law, communication. So there's a lot of opportunities to get involved in the with the AER and also being able to participate and support the deployment of CCUS. We hire people in different streams. We have specialists, support staff, and also some those in management. I also highlight that we do have summer student programs as well, where we actually um, uh, offer position to summer students, co-op students, as well as students who are undertaking practicum. Every year we do that. And so if somebody is interested, they can always reach out to our website. As I'm speaking, we do have a list of summer student jobs posted on our website. So if you know of somebody who's interested, you can direct them to take a look at it. We don't expect summer students to have all the skills that we look for, but at least throughout their growing up and going to school, they would have learned how to solve problems, how to think critically. Some are analytical, have good judgment. They should be adaptable and easy to pivot if they have to. Good communication skills. So these are just a few of some of the skills that we'll be looking for. Because we don't expect some students to be knowledgeable and have all the expertise in the various areas because they are learning. And then So these soft skills is a gateway to helping people who join the regulator as students to be able to hone their skills in the areas of expertise. When it comes to people who already experience, they may be experienced maybe from the industry or from academia, but they are not regulators. And so when they come in, they can come in with their broad knowledge in the industry, and then they can learn to be a regulator by working on projects, applications, supporting hearings, and so forth. So there is opportunity to work for the AER, and I will share that it's a great place to work. And so if you're interested, check out our website for postings. So with that, I think I'm done.
Great. Thanks, Isaac. That was some great information. In general, an overview of what the regulatory system looks like from the perspective of the regulator, and of course, we are talking about working in CCUS, opportunities that are out there, and certainly the regulatory area is one that people can explore if they're interested in working in CCUS. So thanks for that information. What I'd like to do now is invite Matt to make some comments. We've taken a look at the uh, at at the regulatory overview from the regulator, and now we'll take a look from the commercial perspective and explore the regulatory environment in Matt's experience with Bison.
Sure. Well,
So
thanks.
Matt, yeah, I'll hand it over to you.
Sure. Thanks, Tamara. I'll maybe address it in the context of the 5 questions you raised, and I maybe just start with our perspective is really that of a transportation and storage service provider in the CCS value chain. We're at present anyway not engaged actively in delivering the capture part of the solution, or we don't have expertise necessarily in the crediting or in the utilization side. So our perspective is really a transportation and subsurface storage provider. Our our experience in the process, I'd say we're well advanced. I think we could say. I think we're through a couple of the early gates, but we're clearly not complete. So, we're kind of given a bit of a health check on where we're at, but we're not at the finish line yet. So, I'm sure there'll be more things that we learn as we go. And but I think our view, especially on regulation in general and how our experience has unfolded in this process so far, is very consistent with the experience we've had over almost 40 years now of working in the basin in Alberta. So many of the points that Isaac raised in terms of the experience of the regulator and how they draw on oil and gas in general, we would echo that. And in fact, in the ways that this industry appears to be regulated now, we would say very consistently with how we've been treated or fallen under those regulations in Alberta over decades. So that's part of the advantage here really, is we're starting with a very, very solid backdrop. And so with that, maybe just the role of regulations in the sector, clearly the facilitation of the safe and responsible management of the province's resource and delivered in a manner that's consistent with what's embodied in legislation in Alberta. And in this case, it's the delivery of or the management of pore space for CCS. So that's the resource that we're dealing with, and that in this case Isaac is managing. And the real pertinent legislation on that side, in our view, is the Mines and Minerals Act, and it sets out what the expectations are for us and what we need to do. The AER really embodies the technical expertise, the experience, and the capacity for the government's side of this to engage at a very high technical level, which allows them to assess the risk, look at what we provide, and really opine as to whether it's adequate or not. Even to the level of understanding the sophistication of many of the mitigation strategies that we might propose, and also as we get into the operations, interpret our perspective of the relative performance and responsibilities versus what we've suggested is going to happen. And really, when required, they they not only provide approvals, but they are capable of providing enforcement and to the degree that there's potential conflict either between operators or pore space usage, a level of adjudication. So, that it's a key role, and I think when you look at trying to step out CCS in Alberta versus other jurisdictions, that's absolutely clearly one of the big advantages is that we've got a very experienced regulator that lends credibility to that. And as an operator, we can rely on that because there's a tremendous amount of experience that's come from, we would say 75 years of managing things that are at least this complicated, in most cases more. So that's a big advantage for us for sure. How the regulations developed and applied in the CCS sector. The basin has been, we've got lots of experience over a number of decades here. The experience of the regulators is very relevant to much of that. There's a lot of complex applications that have been dealt with in the past, including things that are very relevant to this, like acid gas injection, of which there's literally dozens of small CCS equivalent projects that are running off already that they've had to deal with and manage. There's CO2 EOR projects, and then there's also the Quest project, which is a fantastic direct analog that we can all leverage and build off of. So again, that big component of the CCS advantage that Alberta has, and in terms of the experience with the regulatory framework, to the degree we've traveled through it so far, our experience so far has really shown that it's bespoke to the individual project risks. Isaac mentioned there's a couple of dozen projects. There are some similarities between them, but there's also some key differences. And as we've experienced so far, the questions that we need to answer are very specific to our application. So it's bespoke in terms of what the risks are, where we're at. It's live in terms of the expectation that the performance will drive a continuous reassessment of those risks and the appropriate mitigation strategies. And it's also intended to be quite responsive, that real-time data does affect the way we manage the project. So it's the regulations are quite clear. We've found so far, and not. When we got into it, there's a certain breadth because there's not a lot of people that have gone through and provided the answers previously. The Shell Quest analog, I think, was really, really valuable and quite important, but it's dated now in a number of key ways. But we in many cases we've been able to get, once we have something on the table that can focus the discussion, we've gotten very, very clear guidance on what's required. So it has moved forward, I think, reasonably well in our view anyway so far. How do the companies move forward to receive their project approvals? Well, from our perspective, the full approvals to have a commercial sequestration operation, which we hope to, like you say, have by later this year, it's a gated process. It's multi-stage even within the agencies, and there are several agencies. It involves Alberta Energy, the AR, and AEPA. I think we would kind of maybe categorize ourselves as a relatively early mover here, and if we even said day one was when we were awarded the tenure, that's now been 2 years, and I think we would hope to be maybe out the other end of it by 2.5 years. So that's a length of time. I'd have to say that ours, everybody's moving through a lot of these things in sequence, not in parallel. Some of that is not going to change structurally, like we needed our Alberta Energy approval before we could go to AR. Several of the other processes kind of were in sequence just because they were being developed almost as we were working through it. So I think there's some chance for that to shorten over time, both with experience and companies having a little bit better guide. But I think it's probably going to be at least 18 months at least. But when you contrast that with some other jurisdictions, I mean, there's been people that have been waiting in line for a injection well application approval for several years in the United States in different jurisdictions. And so it's, we've come from a standing start to full pace reasonably efficiently, and I think it's going to do nothing but get better going forward. But, it is multi-staged, and I think one comment on that is that between the agencies, they do appear to rely on the the relative expertise and experience and responsibility of the other bodies. So there's lots of steps, but there's not a lot of duplication. So we've been very happy that the way it was originally set up, there was some areas of responsibility, and you wondered if that team had the backdrop and the capability and the experience to be able to deal with those problems, and would they possibly be better handled someplace else. And lots of that evolution has just happened organically already. And like I say, we have not found a lot of areas where we need to duplicate our provision of information and stuff within the process. So it's refreshingly, it's been pretty efficient so far from our perspective anyway. And how does the existing framework help us lead in the deployment of CCS? I think it's a key tool for sure. And I think that the regulator really provides the oversight that protects the public interest. And I think as importantly as that, it really improves the public's perception of the industry and its potential to deliver industrial scale emissions reductions. So, we've had a couple of pretty active community engagement opportunities, and people are very interested in what this can do, but they're not all. In fact, very few of them are on side with it at the start. There's lots of different things about it that they don't understand. Even in our area, we're quite close to Quest, and you might have thought that if anywhere in the province people had a good understanding, we might have thought that it was in our area. And so that, the public's perception of the industry is still evolving. And I think the AR plays a big role in that. I think that the materials that were available, the process that's been defined gives people, the opportunity to come forward. And I think that's really important. I know on our side, even access to capital is impacted by the quality and the role of the regulator. And that's both in terms of our ability to raise the capital we need to move our project forward, but also as we're starting to hear from people who are looking at voluntary credit markets, their confidence in the market is reflected in their confidence of the regulator to many degrees. So I think it's a perception issue at the start, but I think that that's going to be borne out in the long term. And then I think that it does also give, I think, some confidence to project proponents. I'm not sure what I would expect if I was developing a project in a jurisdiction that had not been involved in oil and gas regulation over time. I'm not sure what I would expect in their reaction to some of the problems and issues that are for sure going to develop as we go forward. We've got a history here of how the AR does handle those issues. And I think as a project proponent, that's beneficial. So I think in many ways it kind of assists with delivering this at scale and relatively early. And then as far as career opportunities, I think I might broaden it a little bit from just the regulatory side to just kind of CCS in general. And I think that we've found so far that there's really definite areas of technical expertise in geosciences and engineering that have not been the typical focus of the upstream oil and gas business, and I think we'll need to get better at those and develop a broader skill set to deliver those with CCS at scale over a long period in Alberta, and whether it's the process engineering around the capture strategies, which are really exploding, or the seismicity that Isaac had kind of highlighted, which is a real issue, and I think it's going to become a bigger one. And the reservoir modeling aspects of this are more detailed than we've seen in lots of different things, and also things like the plume monitoring, different aspects of both the surface and subsurface MMV delivery, the geomechanical stuff and the geochemical reactivity and things like that are at a detail that hasn't been common in many upstream activities previously. So, and whether it's at the regulator, or I think there's also an opportunity with the service providers. There's not a a deep inventory of capacity in the service sector for some of these really specialized things. So I think there's an opportunity there for sure that, when you look at it in the context of if even a third of the projects move to commerciality, Alberta will be the most active place in the world for CCS project development. So, it is an opportunity, and we'll see how it unfolds here.
Thanks, Matt. That was a great summary of Bison's experience through the regulatory process, and as you mentioned, hopefully coming to a close soon. So that certainly means, like you said, it's an exciting time for Alberta. That really, as both you and Isaac mentioned, we have 2024 hubs proposed here in Alberta, and the activity is really just starting. So we've got a lot on the horizon for the CCUS sector, and it's an exciting time if you're considering where your next career opportunity might be. So we do have just a couple of questions in the chat, and I just want to encourage everyone, if you do have a question for our speakers today, please do type that on into the chat or the Q&A box, and Kaylin and I will make sure that we get through them. So we do have a question asking about if there is a public notice and comment period for MMV plans. So maybe Isaac, I'll ask you to take that one.
So there is a public notice of application for the D65 scheme approval as a whole, of which the MMV is a component. And so if somebody is interested in looking at that application, they are welcome to do that. We do have 30 days for a company or an individual or a stakeholder who feels that they are adversely impacted by the application to file an SOC to the regulator, and we'll look at that.
Okay. We have another question in the chat as well, related to the Shell Quest project, which we've talked about today because it is the first sequestration project in Alberta tied to oil sands activity. And it's just a question about if the Shell Quest project might have some injectivity issues into the Cambrian aquifer, and if this happens, how is the CO2 handled operationally? Is there a risk of some of it being vented?
Well, I don't think I'm, I could have a guess and an opinion, but I think that's an operational question for Shell. Part of the maybe on a larger scale, the province, one of the initiatives or motivations was that there would be enough projects that everybody had more than one option. Commercially, everybody would have more than one option, no matter where they're at. There's some competition and stuff. So, I think the first round of awards were all in the greater Edmonton or Alberta Industrial Heartland area. So I think if Shell experienced injectivity issues, they could drill more wells. They've got a large tenure there that's got lots of capacity. So, they could make any kind of a adjustment that they chose to. And if it was a more permanent impairment, they could, someone could seek an alternative arrangement, and there's several right in that area. So, Shell's that Quest project has a pipeline connection down to the refinery. So, and there's probably crosses one or two other tenures on its way up there. So, but I think that's fairly specifically related to Shell.
Thanks, Matt. And lastly, I think one of the questions that might be helpful is if someone were either working on a project and preparing to submit an application, or if they were wondering what the process might be like, is there somewhere that they can go to access some resources? Oh, Isaac, you're just on mute there.
Yeah, I can answer that. So we do have on our website the application process for the sequestration scheme on our external website. And we are very open to companies reaching out The AER, we've met with several companies who are even during the evaluation stage, including Bison, Matt. We've met with
Yep.
them. So our doors are very open. If they have questions, they come in and then we sit down with them and we do respond and have them and walk them through what they need to do for purposes of filing an application. Or if there are some requirements that they are unsure about, we clarify what the expectations are or what is required for them to be able to get a good understanding of what they need to do.
And Matt, you mentioned we have some history in Alberta where we can, where we can learn from projects that have gone through the process perhaps before.
Right. Yeah. Both in terms of the applications, like Isaac had said, that once they get to Isaac's desk, they're public. I'm not sure if the question might go back even to the front end of that process, which is the tenure, and might not be totally current. But I know that I haven't heard of the like a normal situation where if we were interested in undisposed crown mineral title, there's a process to request a posting. I'm not sure if I don't think that this has evolved to that level yet. There was the hub, 2 rounds of the hub process, and then the small scale remote process, which I think is still active, but I'm not sure that there's been any kind of third leg to that, and whether I know that there is an intention that at some point there will be a third leg to that, but don't know where that's at today in terms of someone pursuing a grassroots versus one of the existing. I know that at least a couple of the hub projects have transitioned ownership since they were awarded, and there are SSR projects that have evolved as well
Right.
in terms of getting the
We
tenure
do.
to the pore space.
Okay, thanks, Matt.
Yeah.
We do have one more question that came in that I want to get to just before we close off here. So this is a question for you, Matt, and we're asking, what are some of the lessons you've learned with MMV plans, perhaps things that you picked up on through experience and determined to be key to developing those plans?
I think we'd be better positioned to answer that after we have an approved MMV plan. I think that we probably went into it naive to a degree when we started. Some of the areas that we were asked to provide a picture on seemed distant to us in terms of their immediate relevance, and I think we've gained a much better appreciation of their relevance, and so it's learning on the way through for sure, and I think that's going to continue. I mean, one of the things we're again looking at Quest, it's operated really, really well, and when you compare it to other projects globally, it's probably, if it's not the best, it's sure one of the best, and all that information is public and it's available, and I think it gives a pretty good backdrop. But it's almost 10 years old now, so there's lots of new ideas on how some of that information can be gathered, and you layer it onto a backdrop of interpreted seismicity, as Isaac had mentioned, that so there's lots of different areas where things are improving, and I think we've got a couple of ideas of things that we're going to try that seem kind of neat and maybe give us a bit better answer, and everybody's driving towards better data in a more cost-effective manner. And I think that 5 years from now, 10 years from now, there's going to be major strides in that, and so I think we've gotten an appreciation for some of the things that we didn't have before, that we possibly discounted their relevance, and they proved to be quite relevant, and we're learning as we go for sure. So it's but I think we'll know more as we get out the other end for sure.
And what I'll add is that we do have the MMB requirements, guidance, principles and guidance in Directive 65. It just it lays out the outcomes and what companies need to do. And I also say that not all MMV plans will be the same, because it's driven by your baseline data and the risk that is identified as part of your operations, and then the technology that you intend to deploy to be able to monitor the scheme. The technology deployment is also going to impact the post-closure sourcing fund, because the more you have the technology to deploy, it counts towards how the government look at the risk of the activity as when it comes to the payment of the post-colonial social fund. And like Matt said, sometimes those principles and guidance in 365 might seem to be too onerous, but as you dig into the plan itself and try to answer questions related to the containment issues and all of that, then you realize, oh, I think this just drives home the need to be a little diligent in collecting more data upfront. And so that's the benefit of the evaluation state where companies have the opportunity to collect more data than they would have done for, let's say, a typical acid gas scheme. But with the CO2 sequestration, there's more work upfront to ensure that companies understand what they're dealing with, what are the risks that they identify, what proposed mitigation strategies do they have built in their MMV plan, and how are they going to ensure that they are monitoring to detect and demonstrate that the CO2 is contained.
Super. Well, I think that wraps up our question period. It was a little fast and furious, but thank you both. So Matt and Isaac, thank you for joining us today and for our discussion on the CCUS regulatory environment. Before we let everybody go, I'll just ask Kaylin if she can pop up a quick final few questions we have for you to answer for us today to help deliver events that provide the information you need about the CCUS sector. So we're just looking for some feedback on the quality of the webinar today and how valuable the information we presented today was. And we're curious if perhaps we've inspired you to consider a career in the CCUS sector. And if you'd like to learn more about the industry or the regulatory environment facing the industry at this time. Once you've answered those questions, please click submit at the bottom of the text box and we'll collect that information. So thanks for your participation. So I appreciate the conversation today. I learned a lot, and thanks to both Matt and Isaac again for joining us. Carbon Management Canada has been working with the Government of Alberta to develop a library of resources on the CCUS sector. Today's webinar is just one of the educational resources available. So please do visit the albertacarbonhub.com to access more content like this and to expand your knowledge of Alberta's CCUS sector. So thanks for joining us, and I appreciate your time and discussion today, Matt and Isaac, and appreciate you shedding some light on the CCUS regulatory environment. Thanks for joining us, everyone. Have a great afternoon.